everyone. Welcome to the book event held by Center for Legal Innovation and Digital Technology here at the Chinese University of Hong Kong Faculty of Law. Today, we have a prestigious speaker, Professor Marketa Trimble, here to introduce her book about the EU geo-blocking regulation. And we also have two distinguished discussants, Professor Cui Guobing from Tsinghua University and Professor Wu-Tak Ho, who is currently visiting us here at CUHK, and a professor at the University of Southampton. Let me briefly introduce our speaker. All these discussants and speakers are of course, prestigious scholars, so all good friend of mine. Professor Marketa Trimble is the Samuel Lionel Professor of Intellectual Property Law at the William Bowie School of Law at the University of Nevada in Las Vegas. So he's an internationally leading scholar in our field, in IP, as well as private international law. So she has a lot of publications and books published by, of course, prestigious publishers such as OUP. Our discussant, Professor Guobing Cui, is a professor in Tsinghua University Law School. He is also the director of the Center for Intellectual Property in Tsinghua University. So I always feel that Guobing is the best IP scholar in the greater China area in our generation. So he also focused on different kinds of issues relevant to data governance. My colleague, Professor Wu-Tak Ho, is Professor of Commercial Law at the University of Southampton. She is also a leading scholar in different kinds of transnational legal issues associated with the internet governance, especially jurisdiction. So I think we have a great combination today. Without further ado, I am now passing the floor to Professor Trimble to start this book event. Marketa, please.
Thank you very much, Professor Lee. It's a great pleasure to be here today to talk about my new book. What a pleasure it is, and thank you to the organizers and also to Professor Call and Professor Cui for joining me today in discussing my book. So my book came out in June of this year, and it is about the EU geo-blocking regulation, the regulation that was adopted in 2018. The book took about 2 years in the making, and it is for a broad audience. The book should be of interest to lawyers, certainly judges, academics, students, but also to technical experts who might be involved in employing geolocation, geo-blocking tools, and might wonder what the legal environment is like in the European Union. The book will certainly be of interest to experts in the European Union who are dealing with this particular legal environment. But frankly, it should also be of interest to anybody outside the European Union, particularly to those who do business in the European Union online. So there will be plenty of entities, persons, businesses who are active online, do business online. If they offer any goods or services to consumers, and we will talk about the fact that it's not only consumers, it might be also other customers in the European Union. Those entities, businesses, persons are all bound by this regulation. So it has a broad geographical scope, similarly to the GDPR, the General Data Protection Regulation. This regulation also has a very expansive geographical scope and is binding for many outside the European Union. The book might also be of interest to legislators. Frankly, some of the lessons of the regulation are very hard to transfer to other countries, other regions, other parts of the world. And it's really hard to imagine that the regulation could be a template for an international treaty or something like this. Nevertheless, there might be some jurisdictions where legislators might be considering adopting regulations, laws in a similar direction. And for all those legislators, this book should be of interest and of some assistance. The book is about the regulation that was adopted in 2018, but it's not only about the regulation. The book includes 2 long introductory chapters, and the first chapter is about geolocation and geo-blocking in general. It introduces the concepts, it talks about their technical underpinnings, and also about legality or illegality of uses of geolocation, geo-blocking, and also of circumvention of geo-blocking. So that's a very general chapter that discusses all these legal problems from a comparative law perspective. So it talks about national laws of different countries, not only of the European Union, and compares some of the approaches to these issues in different parts of the world. The second introductory chapter talks about the history of the EU digital single market, the initiative in the European Union of creating one single market on the internet in the digital environment. And it also traces the history of the adoption of the regulation. So the second introductory chapter is very helpful for anybody interested in the regulation because it lays out the history of the legislative process, all the different steps, it introduces all the different players that were involved in the legislative process, and explains some of the hurdles that the legislators had to overcome in order to adopt the regulation. So that's just as a brief introduction. Let me just tell you what I will cover today. I will first talk in general about geolocation and geo-blocking and define the terms for the purposes of this discussion so that we know what we are talking about. Then I will talk briefly about the history that predates the adoption of the regulation and the creation and the plan for the European Union digital single market. Then I will talk about the regulation itself and give you a brief overview of its content. And in the end, I will talk about the future. And in that section, I will share some critical remarks about the regulation, talk a little bit about what the regulation doesn't do and might and maybe should do, and also what we might expect from the regulation in the future. So first of all, let's talk briefly about the main terms that are here at issue. Geolocation is any technique that leads to the determination of location of a person, of activity, of device. On the internet, it refers to the ability to identify the physical location of a user, of an entity, typically of a user. In the old days, geolocation originally was determined solely by Internet Protocol addresses. These are addresses that are assigned to any device that is connected to the internet. Originally, the IPv4 system was a numerical string. Nowadays, we also have the IPv6 version, which has alphanumerical strings. Now, the IP addresses are not like physical home mailing addresses. They don't actually lead to a particular location in the physical world. As a matter of fact, often service providers assign these Internet Protocol addresses dynamically, meaning that every time a device is restarted, the device receives a new IP address. In that system, it's really difficult to pinpoint the physical location of any particular IP address at any given time. There are also IP addresses that are being assigned statically, particularly the IPv6, which are alphanumerical addresses. There are many more of them, and so it's easier to assign them statically. Of course, those are much easier to assign to a particular physical location. But we don't have an address book. We don't have an address book where IP address would correspond to a physical address. But we do know that IP addresses have been assigned in batches to different parts of the world, and within those parts of the world to different regions and different countries and different districts and different ISPs. So by IP address, we can roughly estimate, based on the ISP who is assigning that address, where the IP address user, the device that's using the IP address, where it's currently located. But it's a very imperfect system, and the determination of the location is very rough. These days, however, companies that do specialize in geolocation have other systems, other factors that they use to determine the location of a user in a much more specific, precise way. They use Wi-Fi signals, they use GPS signals, they use various triangulation methods, and sometimes they even harvest social media information about users in order to more precisely geolocate the users. Geo-blocking goes one step further. Geo-blocking is a technique that uses geolocation of a user to determine whether or not certain content on the internet should be available to the user. The term geo-blocking has been used in various ways. The geo-blocking that we are talking about today means geo-blocking that is imposed by the content provider. So the website provider, the provider of the content, will decide whether a user from a particular location should be able to view the content or not. And if not, the user is being blocked by the provider of the content. Of course, geo-blocking services now exist as third-party services. So websites itself, the content provider itself, typically doesn't run geo-blocking on its own. They typically purchase services of some third parties to do geo-blocking for them. Geo-blocking has been used for many different purposes, including security on the internet, certainly for online banking. But typically geo-blocking has been used for market partitioning. As any market partitioning, it is a useful tool to price discriminate or create pricing that corresponds to particular parts of the world. Geo-blocking has also been used to comply with national laws that, of course, vary, and sometimes content providers need to make sure that they don't violate certain countries' laws, and they might geo-block to block access to their content from those particular countries where the content might violate laws. Certainly, we have seen geo-blocking used quite frequently for copyright law-related purposes. So licensing of copyright content might limit where content provider can, may, or wants to show its content, and geo-blocking is useful in blocking access to the content from countries where the provider has no license or for some other reason doesn't want to share the content. Now, of course, geo-blocking is not impermeable. There are various techniques to circumvent geo-blocking. And one of the amazing things about this world is that 14 years ago, when I started researching legal issues of geo-blocking and circumvention of geo-blocking, most users, everyday users, didn't know about geo-blocking or knew very little about geo-blocking and its circumvention. I still meet people who heard me talk about it 12 years ago who now tell me that I was the person who taught them how to circumvent geo-blocking. Not sure I should be proud of that, but that's what they tell me. But 14 years later, I now meet children from elementary schools who know more about how to circumvent geo-blocking than I do. So certainly the whole world has changed quite a bit in this respect. One thing that I would like to emphasize is that geo-blocking is often presented as the problem, as the cause, but in fact, geo-blocking is a symptom. It's rather a symptom of other issues that we see play out on the internet, rather than problem or cause of its own. So this is the world of geolocking and geo-blocking. There is, of course, there are a lot of issues with legality and illegality of uses of geolocation and geo-blocking. In some circumstances, there will be actually illegal. In some circumstances, they will be legal. There are issues certainly related to privacy and personal data protection. There are also issues related to free trade and cross-border trade. So there are many, many legal aspects that are involved in geolocation, geo-blocking, and also in circumvention of geo-blocking. So how did all this come up in the European Union? The European Union has been always keen on creating a single market. Although it is still a union of independent countries, the strength of the union, of course, is very much in its trade, in its economic power. And of course, that can be emphasized if it can benefit from a joint one single market. So the plan for this barrier-free single market has been really the plan of the European Union, or originally European communities, since its inception in 1958. In 1985, it actually received an important boost in the form of the Schengen Agreement. And the Schengen Agreement established this area without internal physical borders. And of course, for cross-border trade, for free movement of goods, services, of persons, this area without physical borders has been very important. It took until 1995 to fully implement the Schengen Agreement, but it played a very important role in creating this physical single market in the European Union. We might think of the geo-blocking regulation as something that was designed to achieve the same thing online on the internet that the Schengen Agreement achieved in the physical world. We can think about that this way. So in 2008, the economic downturn, of course, hit the European Union very hard. And the European Commission started looking for ways to boost the European economy. And they, among other things, focused on the internet, on the digital economy, and on this plan to create an EU digital single market. Not surprisingly, the existence of barriers on that market became a very important topic. And so in 2010, a document called Digital Agenda for Europe talked about the need to remove barriers to cross-border transactions within the European Union. Similarly, in 2011, the Single Market Act document talked about the need to propose legislation that would rule out geographically based differentiation in e-commerce inside the single market. As far as one can tell, the first time the term geo-blocking appeared in European Commission documents was in 2012 in the communication on content in the digital single market. And by 2015, geo-blocking as term was quite common in European Union documents. Now, when thinking about how to remove these barriers from the internal market, digital market in the European Union, the separate regulation was not originally on the table. We see, for instance, in 2016, the European Parliament issued a regulation towards a digital single market in which the Parliament actually expressed its support for other ways of addressing these internal barriers on digital single market. They supported the idea that then existing legislation could be revised. They were particularly looking at the so-called e-commerce directive and the services directive from 2006. And also that this could be combined with stricter application and stricter enforcement of other European Union law, particularly competition law. So those were the ideas for how these internal barriers on the digital market in the European Union could be addressed. However, the European Commission at the end of 2015, in a document called Digital Single Market Strategy, presented its plan to propose a separate legislation that would be specifically on geo-blocking. And with that plan, the Commission launched two studies. One was a sector inquiry into e-commerce of goods and digital content in the European Union. That was an inquiry that was conducted based on the European Commission's power related to competition law. And then separately from that, the Commission has also launched a public consultation on geo-blocking and other geographically based restrictions when shopping and accessing information in the EU. And this public consultation was conducted based on the European Commission's powers in the area of the internal market. Now, until now, I didn't really talk about copyright law at all, but it is important to mention that from the beginning of the discussions about geo-blocking, copyright law-related issues were very much on the table. As many of us can imagine, the European public, or certainly many in the European Union, expressed quite disappointment with the limits on accessibility of content on the internet, and particularly content that is protected by copyright. So European users were disappointed, many of them, that they cannot access the same content as their peers in other European countries. Netflix was divided. What Spanish users could see on Netflix, Estonian users couldn't see. Even the offerings of online music, digital music, were different. What a Greek user could listen to, a user in Finland might not have access to. And of course, we know that many content industries do launch their content in a staggered manner. Particularly the motion picture industry typically releases films in a staggered manner. And they do use geo-blocking to achieve this staggered release. So there was a lot of opposition to geo-blocking because of copyright related issues. And frankly, it was also the most visible geo-blocking, because frankly, users often didn't notice that they were being geo-blocked or that they were exposed to different pricing, right? That was not sort of visible to them right away. They might have learned about it later on. But what was very visible and what users could see immediately was if they tried to watch their favorite BBC TV show, and instead of the TV show on the screen, they got a message, sorry, but your content is not available in your location. And sometimes it even said because of licensing issues or because of copyright. So that created a lot of opposition among the public against geo-blocking. Therefore, there was a huge hope in about 2014, 15, 16, that the new regulation would address access to content, not only to goods and services and to interfaces, but also to copyrighted content. Of course, a topic that was very popular with voters and therefore also very much on the European Commission's mind. Nevertheless, when the Commission started discussing the draft regulation with various stakeholders, including large copyright owners, it very quickly learned that it was not so easy to eliminate geo-blocking, and that there was quite a bit of opposition in the copyright-heavy industries against eliminating geo-blocking for copyright purposes. The regulation was finally proposed in 2016. It took about 20 months to adopt the regulation, which is not out of ordinary. That was about slightly above average at that time. The regulation entered into force in March 2018, and it became applicable in European Union member states in December 2018. The regulation also applies in general in the European Economic Area. So for the additional 3 non-EU EEA countries, the regulation became applicable in 2020. We should also mention that, of course, since the end of December 2020, the regulation no longer applies in the United Kingdom. And on the other hand, we should also mention that the regulation has a little bit of broader effect because, of course, countries that are looking to accede to join the European Union have to start adopting the rules of the European Union ahead of their accession date. So they might be actually following the regulation earlier. The regulation, considering it's relatively short compared certainly to some of the later digital single market regulations in the European Union, is a surprisingly complex piece of legislation. Thus, my entire book about it. The regulation intersects with a number of areas. It, of course, intersects with several fundamental rights as they are spelled out in the Charter of Fundamental Rights of the European Union. It has very strong ties to consumer protection law in the European Union. It intersects with various measures in the digital single market, even with the ones that post-date the regulation. So, for example, the Digital Act and all that, all those other Digital Services Act, it concerns the regulation and will intersect with the regulation. There is an important relation of the regulation with copyright law, with competition law, certainly with data protection law, payment services laws, and so forth. So geo-blocking, the regulation is really set in this complex relationship with these other areas with which it intersects. That made it also very complicated to negotiate the regulation in the legislative process because it very quickly became apparent that it really has to interact with all these different other regulations and other areas of law, and some of it really created quite a bit of friction. So let me tell you briefly about the content of the regulation. The regulation is really not about geo-blocking only as the technical means, but it's rather about prohibition of discrimination. The regulation talks about prohibition of unjustified discrimination, which has also been prohibited in the 2006 Service Directive. But there, the term unjustified was never really clarified. And so the geo-blocking regulation should assist in clarifying what unjustified actually is. So for the purposes of the geo-blocking regulation, the unjustified discrimination is discrimination based on a customer's nationality, place of residence or place of establishment, and also with respect to means of payment based on some other factors. There are a few things you might notice right away. The prohibition is based on customers' nationality, place of residence, place of establishment. It turns out it's not only about consumers, but also about customers who might be also entities and businesses. And the other thing that you might notice is that it has nothing to do with geolocation. In fact, it has nothing to do with the current place, current location of the user. It has something to do with nationality, which might be different from the current location of the user. It's about place of residence, which might be different from the current location of a user, and the same about place of establishment. So the regulation actually introduces this fiction that says that the current location approximates nationality, place of residence, place of establishment. The regulation prohibits discrimination in terms of access to online interfaces, access to goods, access to services, both in services in terms of electronically delivered services and physically delivered services. And also it prohibits discrimination as to means of payment. The regulation is based on this idea, shop like a local, which means that it doesn't really force traders to deliver goods or services where they would normally not do so. But if they deliver goods and services in certain member states, that's what they should do for all EU customers without any discrimination. The regulation also addresses a relationship with competition law, particularly with vertical agreements. Those are typically the agreements where one business will try to tie another business and impose obligation to geo-block. The regulation started off with a provision on this that probably was meant to mean something else than what it does now in the regulation. So one of the topics in my book is what really happened in the legislative process and how the resulting provision might actually not really be what the original designers, legislators had in mind. The regulation also has a provision about enforcement, which is left up to the member states. And also it has a provision about assistance to consumers, which is again typical with consumer protection laws, although in case of this regulation, interestingly, the assistance is also only for consumers, but not for other customers who are not consumers, so not for the business customers. In the legislative process, there were three important controversial points. The first controversial point was that some countries really wished for the regulation to apply only to consumers, physical persons, non-businesses, while other countries and the Commission wished for the regulation to apply to all customers, consumers, but also businesses, as long as they are using the given goods, services for purposes of end use. And of course, this is very tricky because it might be very complicated for a trader to assess ex ante whether the purchase, whether the offer is to a business who is pursuing end use or not. Probably the most controversial point, though, was the exception of copyright protected content. So in Article 4, Paragraph 1, letter B, the legislators in the end agreed to accept those electronically delivered services that concern copyright protected goods, copyright protected services. And that's, of course, a significant exclusion that disappointed many in the European Union who hoped that this regulation would completely eliminate geo-blocking for copyright related services. And that hasn't happened. Additionally, I should point out that the regulation excludes completely from its scope all audiovisual services. So certainly all motion pictures are excluded from the regulation. And finally, also what was a huge controversial point was the effect of the regulation on vertical agreements. Again, agreements on passive sales, if they are in conflict with the regulation, are prohibited, but agreements on active sales are actually permitted, even if they are not consistent with the regulation. So that was another significantly controversial point. And at the very end of the legislative process, the last 2 points, the exception for copyright and the question of vertical agreements, were sort of the keys problems that had to be agreed upon between the Commission, the Parliament, and the Council of the EU for the regulation to be adopted at all. So that was a very brief run through to the content of the regulation. And let me say at the end a few words about the future and some of the critical issues that the regulation might face in the near future. The regulation will be regularly evaluated by the Commission. That's actually in the regulation. And the Commission has already taken steps in that regard. The Commission was late with its first evaluation because of the COVID situation. But since then, since 2020, the Commission conducted stakeholder dialogue. The Parliament discussed the regulation. We have seen some competing, contrasting views among the Parliament members on the question of coverage of copyright or exclusion of copyright from the scope of the regulation. So that has been going on, and certainly we have also seen quite a bit in terms of reporting on what's going on with the enforcement of the regulation. Particularly helpful in this regard are 2 position papers that were published by the European Consumer Centers Network, which is the network of national centers who are in charge of assisting consumers with questions concerning the regulation. And of course, as happens, these centers are also very helpful in helping consumers figure out enforcement issues. So their information is very valuable. The Parliament issued a resolution on the implementation of the regulation in December 2023, and it expressed some wishes for the legislators to consider it, for the Commission to consider it for the future. And including in that is re-evaluation of the scope of the regulation. So there are a number of exclusions from the regulation. I mentioned the audiovisual content, copyright protected exceptions. So for all of those, the European Parliament wants to see the Commission go back and re-evaluate these types of exclusion from the regulation. So what can we expect in the future? Certainly, there will be a continuing pressure to eliminate the exception for the electronically delivered services with copyright protected content, and also for audiovisual services. There's a huge public pressure on the Commission to do something about this. We might debate whether it's purely grassroots movement or whether there are other players who are fueling these demands. But that's certainly something that is apparent. There's an interest among some stakeholders and some users to see geo-blocking eliminated for copyright protected content and for audiovisual content. What I think is problematic is that there are some positive effects of geo-blocking that are thoroughly underestimated in the European Union. One of the underestimated aspects is the effects that the uses of geo-blocking can have for competition and the dangers of eliminating geo-blocking in terms of creating large-scale consolidation. So among the greatest opponents of the expansion of the geo-blocking scope, geo-blocking regulation scope to copyrighted works and audiovisual works are, of course, motion picture studios, particularly European motion picture studios, who work on co-productions where they actually need geo-blocking to do their staggered release. Also, ebook producers, publishers are concerned about expanding the scope of the geo-blocking regulation. One of the concerns is that if you eliminate geo-blocking within the EU, all content will have to be licensed EU-wide. So licenses will become more expensive, and that might outprice smaller content providers. Think of a small local radio station or small local television station. They probably benefit from being able to license content only for their particular region, country, or part of the country. If they have to pay for an EU-wide license, it might be problematic for them. So that's a difficult issue. There's a lot of discussion out there whether the geo-blocking regulation supports diversity of content or actually harms the diversity of content, and there are opposing views on that. So that's also something that has to be kept in mind. Among the issues that I think in the future might be worth addressing are some of the questions that are left out there without really being addressed. One of them is the possibility of parallel enforcement proceedings. Geo-blocking, as we have seen in the EU, can now be attacked both under the EU regulation against geo-blocking, but also under EU competition law rules. So you could have enforcement actions in the same country for the same acts by two different agencies. And the question is, how will this get coordinated and what will happen to any penalties imposed in those two parallel proceedings? Also, you could have actually proceedings in parallel in two different countries, either under the geo-blocking regulation in both countries or under the regulation in one and under competition law rules in another. And again, it could concern the same acts. So that should be coordinated in the future. There's also a question about whether this geo-blocking regulation is compatible with algorithmic targeting. Often when I talk about the regulation, people ask me, well, is it still relevant? Is geo-blocking even an issue anymore now that companies target content individually to particular users? So, of course, there is a question about to what extent this regulation applies, because we don't know how much location of the user plays a role in all these algorithms. So that's one aspect of the problem, is clarifying to what extent the geo-blocking regulation applies in algorithmic targeting. The other thing is that as ISPs, content providers, are more and more under pressure to preserve privacy and very much be careful about personal data of their users, they might actually return to geo-blocking as a much better way of targeting content while not really compromising personal data and privacy of their users. Another aspect of the regulation that might actually deserve some clarification is its effect on indirect discrimination. The regulation is a little confusing about whether it addresses indirect or covert discrimination. It talks about indirect discrimination, but in fact, it describes it as a form of covert discrimination, meaning discrimination that looks like it's not based on nationality, but in fact it is. But it doesn't really talk about indirect discrimination, meaning conduct that's discriminatory in the effect, but in a way that actually treats people the same way, but with disparate effects. So that's something that the regulation might also have to address in the future. The relationship with competition law is very complicated in the regulation and perhaps would deserve some clarification. Again, let me just say at the end that the lessons learned from the regulation are not easily transferable to outside the European Union. And we will see whether legislators in other jurisdictions take on the idea of eliminating geo-blocking. We have one example, and that's Switzerland, that adopted a very short provision, one little article about eliminating geo-blocking for Swiss users. So we will see whether the geo-blocking regulation will inspire legislators in other countries. So if you want to know more, I hope that you will find the book helpful. Additionally, I've written some other pieces in the past about different aspects of geo-blocking, including more, for instance, copyright-related issues. So those are also in the slides in case you are interested. Thank you very much for your attention, and I'm looking forward to the questions.
All right, thank you, Marketa, very much for the very insightful sharing. So I did have this pleasure, enjoy reading the book. So for those who have not yet get a copy, I would highly recommend. So this is a great monograph, kind of like analyzing the interaction between international business, geopolitics, regulation, and technology. Now let's start our discussion. So I am now inviting Guobing to probably have the first round of questions and comments.
Okay. Professor John, can you hear me?
Yes, very clear.
Okay, great. Okay, thank you, John, for inviting me to this wonderful event. And thank you for your introduction at the very beginning. I really felt great complimented. Actually, you are my real IT hero in this field. Here, I also want to take this opportunity to congratulate Professor Marketa for publishing this very interesting new book on the EU geo-blocking regulation. And also thank you for sharing the new book with us. For me, I think that's this kind of presentation very helpful. Just in 40 minutes, give a very brief introduction to the legislative history or the controversial issue, and also probably the future tendency. I happen to read several chapters that are available online. This book provides a very detailed commentary on the regulation, article by article. Really very impressive. I'm sure the commentary would be essential reading for lawyers or academics who are interested to understand the regulation. For me, this book is of special interest. Personally, I have written several articles on content filtering issue under the copyright law. Now I'm keep thinking about writing another article on the website blocking measures, right? Its rule under copyright law. Sometimes that's allow pirate content in a website, but it's very difficult for the copyright owner to get this kind of remedy. And within China, right? Maybe you are thinking about impose some kind of blocking measures against them. But of course, just like the issue Professor Marketa mentioned, consumer rights or freedom of speech are at the stake. So it's pretty complicated. So today, I think from this lecture and also from the reading of the book, I think that get a lot of hints. Now I do have several questions. The first one, since I'm an IP professor, I'm interested in IP-related issue. Here, the regulation create a very broad, as Professor Marketa just mentioned, very broad exception. Say the regulation shall not affect the rule in the field of copyright and neighboring rights. According to my understanding, now in e-platform or all kind of e-business, almost every product has some content, has some implication on copyright, right? So it's possible for the future platform to abuse this kind of exception. Say, since, for example, the package of the products has copyright content, or the trademark has been copyright work, something like that, they probably will argue they could rely on the exception to resist the application of this kind of regulation. Could that become an issue? Another one is also, as I understanding, this regulation also create a exception and a voluntary base, right? Say if the party or the users agree to switch to other website, and then you could do this kind of geo-blocking or the kind of geo discrimination. I'm wondering whether this kind of contract term could also be abused. That's the first issue about whether in the future a website or platform could abuse this kind of exceptions. One is the contract exception. Another is the copyright exception. That's my first question. The second one is about the implication of this regulation for audience outside EU. I'm just wondering whether nationals live outside the EU, for example, a national from a EU member state, but now is living in China, other country. This kind of national are also protected by the regulation. So if they feel to some extent being discriminated by the EU platform, could they seek for protection under this regulation? The first one. The second one, I'm wondering whether a business establishment in foreign countries, but target the consumers in EU, should this kind of business is also subject to this regulation? I think they're very interesting. Okay, I'm looking forward Professor Marketa's comment. Thank you.
Thank you very much for these questions, very important. So in terms of abuse, absolutely correct. We can certainly imagine how this might happen, that companies will try to circumvent the geo-blocking regulation by alleging that their content is copyright protected and therefore they should be somehow excluded from the scope. In terms of the second part of the first question, which is about the interfaces, indeed, the regulation, as you mentioned, allows providers to change the interface, and as long as the user agrees to it, they can provide different interface than the one that the user originally sought. That's very interesting because there will be a question, what is consent by the user, right? What does it look like? Can it be some kind of technical feature that will be interpreted as consent of the user with a different interface? There are some protections. For instance, the user should be able to look at the original interface that the user wanted to see originally. But the question will be how prominent that option will be on the website, how much hidden it will be. So there is certainly quite a bit of room for interpretation in this regard, and that indeed might be subject to some abuse and some playing with the websites. In terms of the exception for copyrighted services, again, if I pull up the language of the exception in the smaller font in the middle, it applies only to electronically provided services, not for goods that are physical goods. So for example, if somebody orders a book, physical book to be delivered, geo-blocking certainly is prohibited for the delivery of the book, the physical book. E-book, electronically supplied, would be accepted under this provision. Now, it's interesting because the interface on which you would purchase the book must not be geo-blocked, right? Or could be only with consent of the user. So the user should be able to see how much the ebook costs, in which country, and should be able to order the ebook without being geo-blocked. But then the ebook itself might be subject to geo-blocking because it is excluded under this provision. I would hope that the language would really encompass only services, as language says, the main feature of which is the provision of access to and use of copyright. So for example, if we are thinking of delivering certain electronic services where, yes, it's a computer program, probably, right? So maybe it is protected by copyright, but it should not be the main feature. And then it would not be covered by this exception. But certainly, given that electronically supplied services will often include some kind of code that might be protected by copyright, that might indeed cause some issues. So that's in terms of your question about abuse. To your second question about the territorial scope, you're absolutely correct. That's also very important and a little bit of a sore point in the regulation. Absolutely, traders who are outside the European Union, if they provide goods and services to customers in the EU, are bound by this regulation in terms of their EU customers. Now, that again can be quite broad because, for example, I like to use an example of a university, for instance, that publicizes its, for instance, graduate program to students in the European Union. The university might not think about this as offering goods or services, but in fact, that's what the university is doing. So the university should be aware of that and make sure that it doesn't geo-block EU users, which could happen. And certainly it could also be that they geo-block in terms of different interfaces. So that's something that the trader should keep in mind. Of course, my students often say, well, who cares? How will they enforce it against us? And I always show them the list of all the penalties issued under the GDPR to European businesses to show them, well, if you want to do business in the EU, you might want to comply with the EU law. And to your second question about EU users outside the European Union, that's actually a quite controversial point because it's not completely clear from the regulation how this will work. Of course, similarly to the so-called EU portability regulation, the EU geo-blocking regulation actually, to some extent, requires content providers to start inquiring about their user's nationality, place of residence, because if you have a user outside the EU, geolocation will not show you that that user is actually an EU user, an EU national EU. The question is, what about if the user is outside the EU, but is ordering goods and services to be delivered in the EU? Certainly in those circumstances, it would seem that the EU geo-blocking regulation would apply. What about an EU national who is outside the EU and is ordering electronic goods to be delivered outside the EU? So those are some of the points that are not totally clear in the regulation. And as I mentioned in my book, there are some competing views about this. Thank you for your questions.
Okay, thank you. First, like another relevant issue about the copyright exception. As you just mentioned, if the product is ebook, that's fine. We'll rely on the exception. But if the physical product is a problem, I'm just wondering, under the EU law, if I grant a copyright license, for example, to distribute a book, and then I set some kind of terms in the contract require the distributor only sell the book at a specific country, right? And then could I, for example, when the distributor start to sell book online, they are subject to this kind of license, right? And that could restrict I think the territory. And then could they do this kind of restriction online?
So an excellent question. The EU law recognizes that there will be circumstances where the copyright license, for instance, will be limited to particular countries. But the EU law prohibits parties from imposing prohibitions of so-called active sales. So, passive sales, of passive sales. So the agreement can prohibit active sales in the sense of, we want you to sell the goods only in this country, and we don't want you to actively go out of that country and promote the sale somewhere else. but the agreement must not prohibit passive sales. And running a website is considered a passive sale. So the idea is with physical goods that the website should be available to anybody in the EU. And if the bookseller is not permitted to deliver goods to other countries, it still must sell the book to whoever orders it online. But the purchaser will probably have to either get to the EU country to which the bookseller is willing to deliver, or will have to have some other arrangement so that the book can be delivered to that other state. With books, it's really hard to imagine, but it's easier to imagine, for instance, with cars, right, with vehicles,
Yes.
where the active sale would be you are not opening new dealerships in countries where you have no license to do so, but you have your dealership open for anybody who wants to drive to your country and buy it there. Right. So I think that that's a recognition that the physical barriers, right, the barriers of shipping and getting to the goods still provide some kind of limitation, while with the electronic delivered goods or services, there's no barrier, right? That's why the copyright got exempted from that, because of the recognition that we could not really limit it in any other way.
Okay, thank you.
Right. Thank you, Gorbin. Thank you, Marketa. It just seems to me that all this online business, they are trying to use technology to build a new virtual border, so which might be somehow different from the so-called jurisdiction traditionally defined. So my colleague Uta is actually an expert in jurisdiction. She has a very important and impactful book about internet jurisdiction published by Cambridge University Press. So now I want to turn to Uta. So what's your view? And you might have some questions as well to Marketa. So Uta, you need to unmute first.
Okay. Can you hear me now? Thank you, Gian, for inviting me. Yes, this is a very interesting topic for me, and I much enjoyed reading various chapters on the book. And congratulations, Marketa, to what I consider is a major effort, particularly as the topic of jurisdiction is just so interconnected with so many other topics, and you're juggling very many different balls, as came through today's talk. Now, I've been thinking about the geolocation or anti-geo-blocking regulation, and I suppose my first question to you would be, do you think it's a success? As a user, the only times I have knowingly come across geo-blocking is in the context of copyright law. And I don't think it makes any change to that. And then I was thinking, well, if it doesn't make a change to that area, to the entertainment industry, who does it actually affect? Yeah. And then, of course, you have the large platforms, which we are all using. But these large platforms have been, I don't think they geo-block really. They have different sites, they have the resources to have offer different sites to different audiences. And so they are really not the target either, which then sort of leaves the small to medium-sized businesses. And then I thought, are they really a fair target for this anti-geo-blocking regulation? Because my feeling is they would be geo-blocking precisely as part and parcel of the right to conduct business freely and as they like, and they might make decisions about wanting to avoid risks to do with offering their products as well elsewhere. They don't want to be exposed to consumer litigation elsewhere. And so they say, actually, we cannot afford to offer our products in another country because we can't afford to defend suits there. So are small to medium-sized businesses a fair target of this regulation? At the same time, are you doing a favor to consumers by allowing them to access goods and services, but on a shop like a local basis, which then means consumers are losing the advantage of being able to sue in their jurisdiction. So I'm confused. So what do you think?
Thank you very much, Uta. Very good questions, of course. First of all, is it success? Well, it depends. It depends. And of course, measuring success of regulations of legislative acts is very complicated. Often the focus is on enforcement. So often people look at enforcement actions and say, you know, if we have enough enforcement, it must be successful. That's a little sad because I would argue no, if you have very little enforcement, that's success because that shows that people complied voluntarily, and that is even better. Well, who knows? In my book, I provide some statistics that suggest that there is perhaps not as much enforcement of the regulation as one would expect. But again, the question is how many companies, how many traders actually decided to comply voluntarily? And certainly the consumer centers have reported a number of instances when they interfered, when they actually got involved in consumer complaints about geo-blocking. And the traders were happy to learn about the regulation and actually complied voluntarily. So often it was apparently an issue of misunderstanding or lack of knowledge of the regulation. Now, the regulation has been in effect for only 4 years, so maybe we see only the starting points for these, but we will see. So in terms of quantity of enforcement, maybe not much going on, which might suggest that perhaps it's not as important as one would expect. One academic actually published a very interesting study in which she went through all these reports and studies that the European Commission had done before it proposed the regulation. And this academic author actually suggests that maybe the Commission was overstating the problem to begin with, and that maybe it was more about pleasing voters and pleasing consumers by adopting something that looked like you suggested, that it will solve our copyright issues, and it didn't. So that might be part of whether it's success. Certainly those who expected that the regulation would open up copyrighted content to everybody in the EU must be unhappy, because that, as you suggested, hasn't happened. The main effect was expected on the electronically delivered copyright protected services, online music, online motion pictures and all that, and that has not happened. So certainly that's where the focus will be for any future amendments. I absolutely agree with your view about small and medium-sized enterprises versus platforms. And one of the things that should be recognized is the interests that are involved in this piece of legislation. The lack of geo-blocking or the elimination of geo-blocking will be in the interest of large players, large platforms. It will certainly be to the benefit of the largest platforms who can afford the licensing, who can do delivery to every single country in the EU. Because of the shop like local, there are still limitations on the effects. So again, the question is whether the elimination of geo-blocking is moving the European Union in the right direction, because to the extent that it's resulting in large-scale consolidation of providers of platforms and elimination of diversity, in fact, right, it might not be where the EU wants to go. As far as small and medium-sized enterprises, As a matter of fact, those that are exempted from VAT, from value-added tax under national laws, are exempted from the prohibition of geo-blocking for access to goods and services. So they did get provision that actually should help them.
Mm.
But again, as you said, because of the shop like a local principle, people will probably opt to purchase goods from large platforms that do deliver to their countries. So even there, I think it will be very difficult for them to compete. So absolutely correct, very good points. Thank you for the question.
I've got a follow-up question, actually. And, you know, geo-blocking sounds like a very sort of technical term and so on. But, I mean, you've made it very clear. It's completely embedded in our trading system and so on. But maybe another sort of stronger angle on it is to think about as a free trade agenda. So free trade within the EU, yeah? And once you talk about anti-geo-blocking regulation, or that they mustn't do it, they're imposing really a free trade agenda on businesses within the EU and those who want to trade from the outside with EU customers. That then means that they are exposed to all the objections one may have to a free trade agenda. Yeah, that it undermines sovereignty, that it's also much more advantageous, what you've just said, to the bigger players rather than the smaller players who might actually benefit from a slightly more protectionist market. So that's on the one hand. But the free trade, there was something else I wanted to say. Yes. It's a free trade agenda, but it's sort of a free trade agenda with a twist, because normally free trade agreements are directed at states rather than at businesses. So, but the anti-blocking, geo-blocking regulation is directed at businesses. So it strikes me as actually interfering in quite a significant way with the freedom to conduct your business as you like, and imposing a European market on local businesses. So yes, so I wonder what your sort of reflections were on looking at the anti-blocking regulation as a piece of free trade agreement, but directed at private players.
Absolutely. Again, you are absolutely correct. The question of freedom to conduct business was raised in the legislative process. A number of countries were concerned about this, and that was also the reason why the Commission in the end opted for the shop like a local, because there was on the table a proposal to make it mandatory for traders to deliver all over the EU. And very quickly, the Commission realized that that was really interfering with the right to conduct business. So that's why they retracted and went back to the shop like the local principle. By the way, it's really interesting. The former member of the European Parliament, Reda, who was a member of the committee in the European Parliament that discussed the regulation, MEP Reda actually wrote that European consumers might be happier with large platforms. Why not? MEP Reda wrote, because the platforms can deliver everywhere and they have better choices and larger choices. It was very surprising to read it from an MEP, given that we are concerned about diversity and about protecting smaller and medium-sized businesses. So that was very interesting. At the free trade area, it's really interesting to think about geo-blocking also in terms of WTO rules, right? And in terms of preventing sort of business going across borders. We had some interesting case in the WTO. Antigua brought a case against the United States on online gambling that actually raised some of these questions. So certainly if it expands beyond EU borders, there will be some also these larger international law questions.
Okay. Okay, thank you.
Thank you.
Thank you, Uta. Thank you, Marketa. So we are now starting our second round of discussion. I know that Guobing is also very interested in a very different aspect, which is about algorithm and geo-blocking. So I will now turn to Guobing.
Okay, thank you. Professor Marketa just mentioned the future probably algorithmic targeting is a new or important issue. I think also very interesting. I'm just wondering if I run a recommender system and determine to recommend different product to consumer from different region. Probably I want to achieve some kind of discriminatory pricing. So if I choose not to recommend some item to a specific group, not to recommend it's a kind of blocking under the regulation. I think they're very interesting. I don't know whether Professor Marketa has given some comments on this issue.
Absolutely, a great question. The Digital Services Act that talks about recommender systems and all that was adopted after the regulation. So there are some interesting questions about the interface of the two legislative acts, and this is one of the few of them. Indeed, again, it's really complicated to figure out how the geo-blocking regulation should really work in the age of algorithmic targeting, because we don't really know what percentage, if any, location plays a role in these algorithms. We don't know. Now, based on the Digital Single Act, the platforms will probably have to tell us something about how they target consumers. But still, it might be a question, what percentage then? Will it be, if it's 5% based on location of the user, then the geo-blocking regulation applies? Or should it be 50% or even more? So that will certainly be a good question. And absolutely with the recommender systems, the same problem, right? It's will it also apply in terms of the recommendations being shown, and is that actually a question of different interface and potential discrimination based on the location of the user? Again, it will be interesting to see as the algorithmic targeting evolves. We have already seen platforms, including in the United States, trying to figure out targeting that's not based on individual user information. So we know that some platforms have played with various versions of algorithmic targeting, such as cohort targeting, where perhaps location might play a bigger role, but again, we don't really know.
Yeah, it seems that when I read the regulation, it seems the legislator actually don't expect this kind of technology, right? They still talk about create a static web page, and then if the consumer agree, you could switch to the second one, and then make it easier for them to move back. So, but in terms of recommendation system, we don't have this kind of static pages, right? I think it's a very interesting issue. Thank you.
Thank you. And I think it also shows the problem of designing legislation for some particular technological environment. The Commission decided not to revise the 2006 Services Directive that prohibits discrimination, unjustified discrimination, and rather opted for this somewhat technology-specific solution. And one has to wonder whether that will serve well, given the fast development of the technology. I mean, the regulation was proposed in 2016, adopted in 2018. It's only 2024, and we are already talking about technology evolving in a way that might not really match the regulation anymore.
Yeah, I have a follow-on question. If the recommender system based their decision on, for example, the education level or the economic situation, but they know this by relying on the geographic information, right? They know, for example, this guy from this area and combined with other elements, we know he's rich, right? I recommend a higher price, a good or high price to him. In this kind of practice, we still believe that's a discrimination based on the geographic information, or actually it's non-geographic. It's only based on economic situation, so it's not covered by this regulation.
So very interesting question. The key problem with the older services directive was that it was not clear what's unjustified discrimination. And a big complaint was that traders would play sort of with the reasons why they were targeting users in a certain way and saying it has nothing to do with unjustified discrimination. They said it would be justified discrimination. So this geo-blocking regulation is supposed to solve that problem. But as I point out in my book, there will still be a discussion of what's unjustified and justified, because there will still be a discussion exactly what you suggested, which is at which point will discrimination based on location be based on nationality, place of residence, place of establishment. So there might be, and the regulation says that there could be discrimination based on other factors, such as membership, for instance, or other similar things. But as you say, it might actually be a case of covered discrimination, where the trader will be discriminating based on factors that they will say have nothing to do with nationality, place of residence, but in fact, they will be related to that.
Yeah. Okay, thank you.
So, Wu-Tao, we have less than 10 minutes.
Yes, I mean, I just wonder, this is again sort of a very broad question. As a matter of sort of blue sky thinking, where do you think the regulation fits in within the greater scheme of things? Is it part of the sort of crazy European second wave of regulation where they, you know, just spurn out one piece of regulation after another without quite knowing how they all fit together? Or do you think it may reflect a general change in attitude towards, you know, sovereignty in cyberspace, and that countries are entitled and can assert their own borders? So where do you sort of put this regulation in a longer time frame?
Thank you. That's a tough question. I think that there are two important features about the regulation. I think the first one is the genuine desire by the European Union to make the Union stronger and more cohesive. So the idea being, if you want to rent a car in Munich, there is no reason why that should be cheaper for somebody in Spain and more expensive for somebody in Hungary, right?
Yeah.
The idea that we want all these European consumers, customers to be on the same playing field and not feel that somebody is disadvantaged, somebody is advantaged. Again, I think there will be a problem with the indirect discrimination, because we still have large disparities, for instance, in income in the European Union. So setting the price point the same way all across the EU is still, I think, creating indirect discrimination and creating other problems. But I understand that that's the desire, right? And maybe that's why geo-blocking is much more acceptable within the United States, right? As opposed to the European Union, where that desire to create one single market is still very much, I hate to say about nation building, because the Europeans probably don't want to be one nation yet, but that's sort of the general idea. The second feature about the regulation, I think it's an interesting sign of times of the development of EU's love story with platforms. So I think when the regulation was negotiated and adopted, it was still at a time when I think many EU legislators viewed platforms and large service providers as the good guys. They were the good people, and they were the innovators, and they were the one, as MEP Reda, for instance, suggested, who were doing very good work. I think in 2018, the relationship has changed quite a bit. I think the European legislators are now much more aware of the degree of lobbying by large platforms. I think that European legislators became more aware of the dangers of large-scale consolidation on the market, including in the digital single market. I think they now view issues of competition on the internet a little bit differently. Certainly, the Digital Markets Act is a sign of that. And they might also see the questions of diversity a little bit differently than they used to. So I think it will be interesting to see what happens to the regulation. The European Parliament resolution from December 2023 is very carefully worded and suggests that there is some very nuanced thinking about the effects of regulation on geo-blocking. And it might be much less one-sided than it was in 2016. So it will be interesting where the things evolve, given that we now have the Digital Services Act and Digital Markets Act, and other pieces of legislation recently, including about the advertising in the election context and so forth, that suggest that EU legislators are much more careful about what's going on the internet and how it gets regulated.
Thank you. Very interesting. Okay.
All right. Thank you. Please.
So a very short question. Thank you for Uta's problem. Actually, I think very provocative. I think I knew a new problem. I'm just wondering whether the legislative purpose of this kind of regulation is really justifiable. If you really force every business to set a uniform price for every consumer in the same market, that probably will cause a lot of this kind of deadweight loss, right? For example, if I could not discriminate against create a discriminatory pricing among consumers in Germany and in other relatively poor countries in EU, then I set a uniform one. I think the price probably relatively high, right? That will sacrifice the consumers' interest from the poor countries. So I think according to antitrust economists, this kind of, in general, this kind of discriminatory pricing is good, right, for the consumer and also for the business. So I'm just wondering whether Professor could make a comment on this issue.
Absolutely, you are correct. That's the classic discussion of price discrimination and market partitioning and about exhaustion also in IP rights, right? That's all related to this. And again, I think it's a little too early for the EU to think about the EU consumers as being on equal footing all across the EU. And in my book, I suggest that we don't know what the future will bring. We think that the EU is headed sort of in this cohesion direction, and we will all be on the same economic level. But we don't know what the future might bring, and there could be new disparities in the EU society. And one has to wonder whether it might not turn out that the geo-blocking could have played some positive role in the future.
Okay, thank you.
Right, thank you. We are very lucky to have three very distinguished speakers and discussants today. Marketa, thank you for staying in office. For those who don't know, it's already 10:30 p.m. in Las Vegas. So to share her book with the audience here. So Professor Trimble particularly asked her university not to lock her in the building. So I think it's time that we need to let her go. And we are also very lucky to have Uta with us these 2 years. Otherwise, I would feel very bad to wake her up like at 5 a.m. So, and also Guobing, has a very important function in Supreme People's Court in Beijing today. So he is actually speaking to us from the Supreme People's Court. So, and once again, I would like to invite our audience in thanking three of you, Marketa, Uta, and Guobing. And of course, I also want to thank all our audience for the participation. I think it's time to end the event today. Thank you.